I need to focus on state accountability. As we all know, international law regulates interstate relations, be they bilateral or multilateral. The introduction of human rights into the UN Charter in 1945, which incidentally was an amendment pushed by civil society to the draft charter, added a third dimension to this interstate relationship, and that is it added the individual, who became the third party in the relations created as a result of international human rights law. The UN Charter contains 8 articles setting out the obligations of states in relation to human rights. And these 8 articles bind all member states. The International Bill of Human Rights was drafted under these provisions. The Declaration was the first component of the International Bill, and since its adoption in 1948, as you know, the Declaration has acquired the force of law, at least as according to the International Court of Justice. Then came the International Covenants on civil, economic and social rights and cultural rights and civil and political rights. And those entered into force in 1977. Under a number of these conventions, these core conventions, states undertook to report to treaty monitoring bodies on the measures taken to comply with these obligations. And the optional protocol to the ICCPR obliges states to respond to allegations by individuals of the state's failure to being protected. Other human rights treaties which came into force over the years remain equally binding. It may be said that the principle of accountability of states has been amply affirmed throughout the history of the Commission on Human Rights and since 2006, the Human Rights Council. The first case which tested the accountability of member states took place in 1946. That year, India raised the matter of, and I quote, the treatment of people of Indian origin in the Union of South Africa. It did so before the General Assembly, where it was first treated as a bilateral dispute. The Assembly recommended at that time, unsuccessfully, a round-table conference to resolve the problem. That did not work, and segregation in South Africa became government policy and enshrined in law. And in 1962, the Assembly established a special committee against apartheid, and apartheid legislation lasted, as we all know, until 1991, when it was repealed. Interestingly, in 1967, the Special Committee Against Apartheid triggered the first of the special procedures by the Commission. We shall come back to this in a minute. Permit me to trace how accountability inserted itself in the work of the Commission on Human Rights. The embryo was the Yearbook on Human Rights, which was launched in 1946. The yearbook was a publication that reflected the first efforts at sharing or pooling information by states on human rights on the situation at the domestic level. Publication was discontinued in 1988, by which time other procedures of accountability had been developed. The yearbooks, by the way, are available on the UN Digital Library. They are a valuable and interesting source for research, and I strongly recommend them. Next came the establishment of a system of periodic reports, which was a primitive version of today's Universal Periodic Review. The proposal to set up periodic reporting was introduced in 1950, and the proposal went through several amendments. Eventually, it was set up 6 years later, and as it says in the book, the evolution that took place between 1950 and 56 was particularly significant, coming at a time when the future of the covenants was still in doubt. It sent a message that states were no longer watertight compartments as far as human rights were concerned, and that there was, whichever way it was interpreted, a form of accountability to the international community on human rights matters. It injected the notion of sharing information for mutual benefit. And under this procedure, all this took place during the difficult years of the Cold War, just before the emergence of the non-aligned movement. Under this procedure, governments would submit annual reports to the Secretary General on development and progress achieved in the field of human rights and measures taken to safeguard human liberty. The evolution from the sharing of information through the yearbook to the provision of annual reports enabled the development of a system of periodic reporting. This system was to last for 25 years, and by the time it was discontinued in 1981, the international covenants had entered into force, and the reporting procedure under the covenants had come into effect. The next phase in the process of strengthening accountability of states came in 1967. That year, the Commission took up the invitation of the Special Committee Against Apartheid to investigate allegations of torture in South Africa. This was the first case of an investigation by a Commission on Human Rights delegation. Although the Commission on Human Rights had not yet taken up situations in specific countries, and even less to investigate, it was a matter of time until it would find itself having to do so. Earlier attempts had not taken off. For instance, in 1957, Ceylon had proposed that the Commission take up violations of human rights in Algeria. That, at that time, was swiftly opposed by France and neutralized through a procedural move by the USSR. The same year, in 1957, China raised the plight of the Chinese community in Vietnam. In 1963, the Assembly sent a fact-finding mission to Vietnam to examine the relations between the government of the Republic of Vietnam and the Vietnamese Buddhist community. That mission ended on 13 December 1963, when the Assembly decided not to continue consideration of this item. Coup d'etat on 1 November 1963 had rendered the original purpose of the mission redundant. This experience broke new ground in a number of ways. It cleared the way for what was to follow at the Commission on Human Rights. The fact that it was a human rights mission and that it was supported by the Department of Human Rights made it so. In 1966, the International Labour Office proposed the inclusion of the question of violations of human rights in Burundi on the agenda of the Commission. The proposal was not pressed after Burundi undertook to send a mission to the ILO to establish facts and hold discussions. Gradually, the focus, which had largely concentrated on drafting the international human rights legal framework, moved on to addressing human rights problems in Southern Africa, notably in the territories under Portuguese administration, in Southwest Africa and Southern Rhodesia. And here, it should be recalled that until 1955, there were only 4 member states of the UN from Africa. Until 1955. These were Ethiopia, Egypt, Liberia, and South Africa. That's all. This then changed dramatically in the late 50s and 60s, with 36 African states becoming members of the UN by 1968. The Commission was enlarged to 32 members in 1966, and this was bound to bring new perspective on human rights work at the United Nations. In the mid-60s, this new thinking arrived at the Commission, and it had its roots in 2 General Assembly committees. The first, in 1966, was the Special Committee on Decolonization. In June 1965, that committee drew the attention of the Commission to evidence submitted by petitioners concerning violations of human rights committed in territories under Portuguese administration and also in Southwest Africa and Southern Rhodesia. This was followed by the request from the Special Committee Against Apartheid, which I just mentioned, about asking the Commission to investigate allegations of torture. And therefore, in 1966, a debate of critical importance took place on the competence of the Commission of Human Rights. The main point was whether the Commission was being asked to look into violations of human rights in all countries, or whether the request was limited simply to racism and racial discrimination in certain countries. In short, it was the decision that opened the way to investigation. The first of these was the so-called ad hoc working group of experts on South Africa, and there is a reason for that title, and followed by the situation in the occupied Palestine in 1969, and the situation in Chile after the military takeover in 73. The Commission formally expanded its mandate to include violations of human rights in all countries, and soon thereafter in, quote unquote, all parts of the world. Hence accountability. As a consequence, at its 1968 session, an unprecedented number of national situations were raised in the Commission. This included the situation in Greece, the occupation by Israel of Palestine after the '67 war, the United States and the war in Vietnam, violations of freedom of expression in the USSR and the Ukrainian SSR, and the situation in Haiti, all in one session in '68. And this was the origin of what we call today the special procedures. Since then, more than 100 countries have been the subject of various forms of inquiry or investigation in public or on confidential procedure. These are all contained in Chapter 6A. And soon, these procedures expanded into thematic mandates, which involves investigation of allegations in several countries, as Special Rapporteur Grover just described. There are now currently over 40 such procedures covering a wide range of human rights, and these can be found listed and historically described in Chapter 6B. The establishment of the Council in 2006 brought with it the Universal Periodic Review, by which the situation of human rights in every member state of the UN is subject of a periodic review. So that completed the whole idea of accountability. The Council has, in addition, established several fact-finding missions and commissions of inquiry on situations in a number of countries. Fact-finding missions have also been dispatched by the High Commissioner in recent years. Over 30 such missions have been established. I have given a summary of the milestones showing how accountability of states emerge. States have been and remain accountable to the international community. Although they have primary responsibility domestically, no state is beyond international scrutiny. That said, from time to time, governments have invoked various reasons to limit or avoid accountability. In the early 90s, for instance, cultural relativism was raised, according to which the universality of human rights was questioned. It was based on the assumption that each country or region was well qualified to protect human rights within the parameters of their respective cultures and traditions. This was effectively addressed by the formulation adopted at the 1993 Bangkok Declaration at the regional preparatory meeting for the World Conference. The Bangkok meeting was a historic event. It was the first time ever that governments from the Asian region had met on a human rights agenda. It should also be remembered for the historic meeting of NGOs and the contribution of that forum to the governmental processes. One cannot address accountability for human rights without mentioning the vital role of civil society. Throughout the history of human rights in the post-war era, it was human rights NGOs who ensured that accountability did work, and little would have been possible without their dedication and sacrifice. NGOs have been subject to reprisals and other forms of harassment and intimidation. Unfortunately, this persists in spite of the declaration of 9 December 1988, which is meant to protect human rights defenders. 7 years ago, the Council launched an initiative requesting the creation of what it called civil society space in their respective countries. But the Council appears to be following a policy to minimize its accountability. A stockade mentality seems to be prevailing, where, for example, governments have kept civil society virtually out of the UPR, where allegations against governments contained in the report of special procedures are sidetracked into the UPR. The admission of large numbers of civil society organizations should be seen as a laudable opening to all or any group, but it also creates a logjam which negatively affects the contribution of civil society in the work of the Council. For instance, over 290 were attended, participate or tried to participate at last year's February session of the Council. These are not encouraging factors, but we hope that the Council will reverse this trend. This time is appropriate. The Council is to conduct a review of its work during the period 2021-2026 and to propose methods and procedures to improve its efficiency. So there you are. It's now in your hands, you gentlemen and ladies, to carry the ball forward to bring about this very badly needed improvement in the methods and procedures of the Council. Thank you very much for your time.